The indictment of Guyanese-Canadian businessman William Mason, along with 4 cohorts, successfully concludes the first round of prosecution in what is being described as a crime of great import. The matter has the potential for far-reaching impact, since Mason is said to be well connected to a number of prominent government officials and politicians alike. This morning, the men, including 20-year-old Ernest Castillo, 29-year-old Kieron Fernandez, 29-year-old Ashton Vanegas, and 30-year-old Terence Fernandez, were arraigned on a slew of charges. Those allegations stem from the purported abduction of 3 men, including 47-year-old Llewellyn Lucas, which resulted in his murder. The commission of those crimes spanned both the Belize and Cayetano jurisdictions.
The charge of murder and conspiracy to commit murder, they both occurred in the Belize Judicial District. So by any account, the court that would have jurisdiction to hear those 2 matters is the Belize City Magistrate Court. As it relates to the kidnapping and the conspiracy to kidnap, again, those read in the Cayetano Judicial District. But again, as the Chief Magistrate rightly pointed out, as a Chief Magistrate, she has jurisdiction over every court, magistrate courts in Belize, and she can make those arraignments. So what she did is to allow the arraignment and then refer the matter back to Belmopan, where they rightfully belong, and that is in respect to the kidnapping and the conspiracy to kidnap. The murder and conspiracy to commit murder remains in the Belize Judicial District.
The case has been divided into individual crimes and corresponding jurisdictions. Attorney Herbert Panton, who appeared on behalf of Mason and the other accused men, says that the basis of his submission were hinged on 2 facts.
There were 2 fundamental tenets to our submissions. One is that this matter was already adjudicated on, so if you bring the same facts before the court, it amounts to forum shopping. And basically the same facts came before the court, with a little addition here and there that did not in any way change the nature of the tenuous nature of the facts. And secondly, what ought to happen is that the prosecution ought to be given their 14 days to get all their facts together. Because I don't know if you were here earlier when I made the point that Mr. Blackett indicated that the Canadian national is not even in country. He indicated that they have gotten 2 separate statements, one in person and one over the phone, both of them conflicting. So that how are you going to charge these people with kidnapping if you have 2 conflicting statements? And he, the top cop, says, we don't know the nature of that investigation, we don't know where those charges will lead as yet. And today you come with kidnapping. It is ridiculous, but we proceed to the next step.
Pastor Lucas was allegedly taken from Mason's residence near Intelco Hill in Belmopan on Friday afternoon and was reportedly beheaded at a ranch near mile 31 on the George Price Highway. Notwithstanding evidence, tangible and circumstantial, Panton argued that there was a lack of proof to substantiate the charges.
I went and I did my legal research and came up with authority to guide the court as it relates to the fact that he was saying that there was not sufficient evidence, when on the face of it there is sufficient circumstantial evidence to indicate that these 5 men are indeed responsible for the death of Mr. Llewellyn Lucas. And when I look at the issue of circumstantial evidence, as I alluded to the court, that it ought not to be taken in a piecemeal fashion, but rather to be looked at wholesomely, and the court would then look to see where it points when looked at holistically. And that was what I did this morning before the court, and as I have said to the court, or as I point out to the court, that the issue of whether or not there is sufficient evidence is not a cherry to be had at this stage.
While that proverbial cherry may not be ripe for the picking just as yet, Panton anticipates what evidence will be brought forward by the prosecution when it's time for disclosure.
We wait for disclosure to see the evidence that the prosecution has against my client. Disclosure is set for the 7th of September, I believe. So we'll see what happens then.
So, how does a relatively unseasoned attorney get to sit in the driver's seat of arguably the most high-profile criminal matter as a prosecutor? Better yet, will Chester Williams remain in the driver's seat going forward?
But I am not sure if I will be proceeding forward with the matter leading up to the preliminary inquiry. I was asked to come and deal with the arraignment today, to be able to rebut those submissions that Mr. Panton had made in Belmopan yesterday, and that is exactly what I did today.
For context, the following is what Attorney Herbert Panton told the media on Monday regarding an application that was filed in the Belmopan's Magistrates Court.
I made an application that the facts of the case as they appeared on the summary that was given to me did not, on the face of it, amount to prima facie evidence to charge them for murder, for conspiracy to commit murder, for kidnapping and conspiracy to commit kidnapping. The prosecutor admitted in court that the facts did not disclose enough evidence to proffer the charges. Based on that, my submissions were upheld. The criminal procedure rules provide that where the facts do not disclose enough evidence, the magistrate, either the prosecutor can withdraw the matter right away, or the magistrate can adjourn it, give 14 days for them to come back and proffer the charges.
That application has been set aside, and all 5 men have since been remanded to the Belize Central Prison until September 14th. Reporting for News 5, I am Isani Cayetano.